Hello everyone, welcome to another exclusive interview in this series. This time we have an exclusive person, Mr. Nihal Jayawickrama, former acting Attorney General and former Permanent Secretary to the Ministry of Justice, and he was in fact the youngest Permanent Secretary appointed to the Ministry of Justice and the youngest Attorney General in the department appointed. So thank you, sir, for agreeing to do the interview with me. What you have done in your life, when we read about you, it reminds us that sky is the limit for a lawyer. Doing litigation in the court is not always the only option you have. Of course, you have come to the legal profession from the legal background, your family background, you have lawyers in your family. So may I first ask, did you choose to be a lawyer, or were you asked to be a lawyer by your family?
Well, the point is, my father was a lawyer, his brothers were lawyers, my mother's brothers were lawyers. That seemed to be the family business, and I think from about the age of 6 or 7, I didn't think that I was going to be anything but a lawyer. So there was no question about it, and so there was no question. And I didn't think I was fit to do anything else. My brother wanted to be a doctor, and there was consternation. Right. He was told, "You can't, because we are not doctors. We don't have it." But he did become a successful physician. But no, I didn't think there was any other option, and I liked the subject, and I wanted to pursue it.
So apart from practicing law after becoming a lawyer, you were involved in number of non-governmental activities, international activities. Am I right?
I was.
You were actually granted in the 1966 UNESCO Youth Leadership Grant. You may be the first person to receive such a grant from Sri Lanka. Why you received that, and what were you doing at that time?
Yeah, I was surprised when they offered that. I didn't ask for it, but I have been interested in non-governmental work even from my school days, and I was involved in the United Nations Student Association, both in school and then in the university. And then thereafter, after I became a lawyer, I was a founder member of Amnesty International, the Ceylon branch, and the International Commission of Jurists, the branch here. So I was very much involved in NGO work with relating to legal matters.
And you were in the Bar Council also?
The Bar Council was a different thing. Yes, I was elected to the Bar Council in a rather traumatic period when there were 2 Bar Councils. And yes, I was secretary of the Bar Council for 2 years.
You were appointed as the permanent secretary to the Ministry of Justice at the age of 32.
Yes.
You were not a per se political party member or political party lawyer.
No, I never.
So, who made the then Prime Minister, Mrs. Sriramao Bandaranka, appointed you as a secretary?
She is the one who.
And what made her to choose you as a secretary?
I don't know. She invited me to be the permanent secretary. She knew me as a lawyer. I had done legal work for her, and I had also been as a Bar Council secretary, been complaining to her about her government not doing anything about law reform, her first government. So I said, at least in the second government, if you will, please undertake the program of law reform. So she knew me, she knew my family also. So when she, after the elections, when she asked me, I said, well, how can I become a public servant? I want to practice law. And in any case, I said, Ministry of Justice, what can I do? Appoint JPs. She said, no. You have a free hand. You can introduce all the reforms you have in mind. We have a parliamentary majority of 2/3, so they can get through. So come and do that. So that it was a difficult decision to leave the bar, because I was quite happy there. At the same time, I was not leaving Hull's law.
But you were not a member of the SLFP Lawyers Association?
No. In fact, the SLFP Lawyers Association protested against my appointment. But I don't think the Prime Minister took any notice of that.
But that was in 1970.
1970. June.
1970 June. But initially you were there for only about a week or two. Thereafter, you were appointed as the Attorney General.
Yes, when the Attorney General passed away quite suddenly, and an issue arose there.
But the record says
Yeah.
Acting Attorney General. Can you explain?
I don't know. I think the letters patent issued by the President, by the Governor General, said Acting Attorney General, and when I took it to him, I had to take the letters patent, the draft for his signature.
Drafted by
one of the clerks in the ministry.
Yes.
I had only been in the ministry for 5 working days.
Okay.
And they told me they have a special clerk who does all the letters patent. Yeah.
Okay.
So I took it with him, and it was urgent to make this appointment because there were certain important decisions to be made. So I took it with him, and then he looked at it and he said, "Well, can you tell whom are you acting for?" So I said, "I don't know. I'm not acting for that." So then you have to act for somebody, no? So I said, yes, and maybe I said, I don't know, maybe this form is not the correct form. But if I now take it back and get it rectified, it will be about 3 o'clock when I come back here, and the other urgent matter cannot be dealt with. So let's do it. So he signed it. It didn't matter to me because I knew it was a temporary thing, and it didn't matter to me how it was described. But the main thing was to complete it. And
so you were there as the Attorney General for how long?
For about 2 or 3 weeks, I think.
2 or 3 weeks.
It was a difficult task because the senior officers were not happy, and the junior officers were my contemporaries, most junior ones.
Right.
So they couldn't have been happy, but they didn't say anything. But anyway, it didn't matter. I was going to be in that premises for the next 5 years.
Right. But 3 weeks or nearly 3 weeks after that appointment, you were again
I was reappointed
as the permanent secretary of the ministry.
Because somebody else was appointed permanent secretary during the time that I was away.
Right. So you were initially appointed as the secretary to the Ministry of
Permanent Secretary
Ministry of Justice for about 5 days. Then, since the demise of the then Attorney General, you were appointed as the Attorney General. There you worked for about 3 weeks. Then again you were appointed as the permanent secretary to the Ministry.
And I was there for the next 7 years.
Next 7 years. So that 7 years, by looking back, reading about the history, so many changes happened in the legal system.
Yes, because
what are the things that you introduced?
I thought that my primary task was to undertake a program of research, of reform. And that's what I set about doing. I found the Law Commission was of no use because they were concerned with technicalities. So I established a legal research division in the ministry, recruited a group of young law graduates who were able to do research. Then I contacted the law commissions of Australia and Canada and got a lot of material from them, what the reforms they had done in their own countries, and also from the UK. And then we began this process of drafting a new criminal procedure, civil procedure, and courts ordinance. I must say it was not original work because I found that some years after independence, I think it was during Sir John Kotalawala's time as Prime Minister, he had appointed a commission called the Criminal Courts Commission, headed by Justice Grayson, a Civil Courts Commission headed by Justice Nagalinga, and a Courts Commission headed by then Chief Justice Alan Rose. And they had prepared excellent reports. And each one, the civil procedure and criminal procedure, had new draft civil procedure and criminal procedure codes. They were there. So I was not doing anything original. I was making use of that material. Then now that's what, 10, 15 years old, getting more modern material from elsewhere, Canada and Australia and so on. And we prepared two rather very comprehensive statutes, the Administration of Justice Law of 1973 and the Administration of Justice Law of 1975. It completely changed modernized the procedures which were found previously in the laws of 1890 and 1889. So that it's nearly 190 years old.
Right.
But of course it was not welcomed by the judges or the bar because it made rather dramatic changes in their lifestyles. If you have to prepare written submissions and submit evidence in affidavit form, it involves a lot of work which they were not used to doing. And judges also have to read much more than what they would normally do. So that.
But those changes speed up the process.
They definitely did. And I found then there was a study on, and also we established conciliation boards throughout the country. The law had been passed during Mr. S.W. Bandaranaike's time, but not implemented. So I implemented that and set up conciliation boards throughout the country. Mr. Jayawickrama, the deputy minister, was in charge of that, and he went around doing this. And a study done about 3 years later by, I think, Dr. Nihal Jayawickrama found that some 53% of the disputes, civil disputes referred to conciliation boards throughout the country had been settled, which means that 53% of litigation had been taken out of the courts.
Yeah.
So naturally the legal profession was not happy, and I had to suffer the consequences of that when I resigned from the ministry and tried to resume my practice. We also had an unexpected event, which was the JVP insurgency.
That you had to face for that.
In 1971 April, the JVP insurgency resulted in, initially after about a fortnight of about 9,000-10,000 people arrested and remanded, brought to the prisons. Then when the military was ready to launch an offensive, Mrs. Bandaranaike said, don't do it. Give the young people a chance to give themselves up. So then we had a whole procedure of people surrendering. What was promised was free transit, that nothing would be done to them. They'd be taken into places of detention. And for that we had to organize not police officers, not army officers, but civil servants, public servants, state council. So they were the people who received them. So then we had about another 9,000. And now there were nearly 20,000 people in custody, of whom half we don't know anything why they had given themselves up. So it meant that an investigating unit had to be set up. The police said that they are not equipped to question these people because many of them are university students, so we had to get public servants to do that.
Sorry to interrupt. Now, during that period, the law gave powers to you as the Permanent Secretary of the Ministry of Justice to retain people who are under investigation, but you didn't like to some of the decisions taken by the CID, so the law changed.
No, not the CID, that's later. But this is the insurgency with these 19,000 people in custody. Under the normal law, they had to be produced before court, and or the judge has to go into the prison. Now that could be done. It was not possible to do it in those circumstances. There's an emergency regulation which gave the Permanent Secretary the power to release, because there was an investigating
Permanent Secretary of the Ministry of Justice.
On the recommendation of the investigating unit to release them. So, and also allowing visits and all that, had to be held by the minister. So I had to set up a special unit under the Senior Assistant Secretary who dealt with that very well. So that process took up a considerable, unexpected event, but we dealt with it. It took some time, about 3 years to complete. Then a question of bringing them to trial arose, and the Attorney General said he can't bring them to trial in every district in this country because these attacks took place in different districts, but one conspiracy. So he said he had to prove that conspiracy about 20 times. Can't do it. So he proposed the setting up of an institution called the Criminal Justice Commission, consisting of Supreme Court judges, but with the power of having an all-island jurisdiction. So that those things took quite a lot of time.
And during your period as the Permanent Secretary to the Ministry of Justice, the first female state counsel was appointed to the department. Am I right?
No. During my time, we in the ministry, I chaired the interview board.
So for the state council, you chaired the interview board as the Permanent Secretary.
Yeah, for the state council, for assistant legal draftsman, for any staff members in the Ministry of Justice, except the prisons, which the prison commissioner did. So I found on one occasion, we interviewed several people, and then we chose 3 people, one of whom was a lady lawyer. and that was Shilani Tilakavardhana. We thought she was good. She was fit to be a state counsel.
So at that time, the Attorney General Department never had a female state counsel?
No, none at all.
Okay.
Nobody. At no level was there a female person. So when I sent the list up to the minister, the Attorney General of the day had met the minister and said it's impossible to have a woman state counsel in the department, and had given reasons. Can she go to Hambantota at 2 hours notice, that kind of thing. And he managed to persuade the minister, I think it was Mr. Jayawickrama at that time, not to appoint. So her name was deleted from the name that was sent to the state services.
So did the interview board ask at that time, Ms. Shilani Tilakavardhana, whether you are able to go?
No, that question didn't arise during the interview.
Right.
It only arose after the interview results were submitted, and the Attorney General found that we had chosen a woman lawyer to join his department.
So her name was cut off by the
minister. He said no.
Though she was subsequently appointed years later.
I think after the change of government. But I made it a point, not long after that, to appoint 3 women lawyers as state attorneys in the Aegis department. Now,
Till then there were no females.
The Aegis didn't mind because they were doing desk jobs. And they didn't seem to mind that.
Right.
But
Sir, now in the history of Sri Lanka, the Parliament has dealt with 3 people with regard to the civic rights. One of them was you. Can you tell, because you said you were not a member of a political party, you were not a member of the SLFP lawyers group. So what made them to put you to that?
The special presidential commissions of inquiry law was passed by the Mr. Jayawickrama. Soon after, he made certain constitutional amendments in 1977 to transfer the powers of the Prime Minister to the President. And that law also said the first Prime Minister, the then Prime Minister, shall be deemed to be the first President. Deemed to have been elected as first President, so not elected by the... Now before that event took place and before he actually assumed the office of President, he introduced a special law to appoint 3 judges to inquire into the activities of people in government, whether politicians or public servants, and to report on whether they have been guilty of misuse or abuse of power, nepotism or corruption. That's all. So, and I think, my own view is that I think it was directed at the then leader of the opposition, Mrs. Bandaranaike, and I think Mr. Felix Das Bandaranaike, because he probably thought that he might be the sort of deputy to Mrs. Bandaranaike. So they were the people who were intended to be targeted, and when the inquiry began with the special prosecutor from the bar addressing the commission for about 3 months with the whole thing broadcast on SLBC and so on, it was against them. But I had gone to London at that time because I had been appointed a research fellow at the University of London.
So soon after you finish with your job for 7 years work as a permanent secretary, you went abroad?
No, I didn't want to go abroad. My intention was to come the next day to Hulstone.
To practice.
Yeah, and I did get some briefs from friendly lawyers who sent me briefs, but I found that I couldn't do that because the briefs were soon taken away fairly soon. And then I heard that there was a campaign by certain senior lawyers to prevent both Felix and me from returning to the bar.
Right.
So I found that I waited for about 3, 4, 5 months, but I found it was not practical to come back to the bar. So I had to look for something else, and I got this offer from London to do a research project on new emerging international human rights law.
That's at the King's College
University of London, and also to submit material that I collect for it for a PhD. I had not intended to do any of those things earlier, but that's the option that was open to me, and I took it. And I went there and I settled down and came back to Colombo after a few months to take my wife and my daughter back. Week after I arrived, they impounded my passport.
Right.
And then I had to stay here until they brought me before the commission on some 40 charges.
40 charges.
40 charges, such as, for example, you did.
Did you frame those charges by
No,
yourself? or by the
it went through a procedure where first they asked me, when I was impatient to get back, they said, okay, you frame the charges yourself. Look at the proceedings. We did that, but that was a big farce. Ultimately, they served charges on me and they began the inquiry. And it went on for 7 months.
Who defended you?
I was defended by Mr. Nadesan QC, together with Mr. JCT Kotalavala and Mr. Faiz Mustafa, who was my batchmate at Peradeniya. They appeared for me for 7 months without charging any fees.
Right.
And it was the charges. I had 40 charges compared to, for example, Felix had about 3 or 4 charges. Mr. Bandaranaike had also about 3 or 4 charges. At 40.
Yeah, 40.
And the 40 charges were different categories. One, the majority of charges were that I had obstructed the investigations of the Criminal Investigation Department in regard to exchange control investigation on the frivolous ground that solitary confinement is not permissible, and that number of things like that, which they said. So that happened because I had a running battle with the CID over keeping people locked up for months.
You were against for that?
Months, of course, for months. And then they were in the prisons which were under my charge. So I used to go there. And then I found that they were not allowed. Doctors were not allowed to come there. They would be not taken out. They are suspects. Not being taken out for exercise. Not being allowed to get food from inside, which remand prisoners are allowed. So we had a big battle. And ultimately, I told the Prime Minister, I can't work with the CID, and if you want these things to go, investigation to continue, please transfer my powers to your Permanent Secretary in Defence and External Affairs, which was done by the government, and that relieved me of it.
By amending the law, the powers were given from the Permanent Secretary to the Ministry to the Defence
Secretary of Defence and External Affairs. And that relieved me of it, but nevertheless I had about 3 or 4 months, 3 or 4 years of this thing with the CID. So there are a lot of charges about that. So those were brought against me. I had also charges which the Attorney General's Department initiated in regard to the detention of Mr. Lalita Ratnagiri, who was then a minister in the government, but who had been arrested on the instructions of the Attorney General on suspicion of being involved in an acid throwing incident. So they were in a problem because...
So was you said you had a charge for restraining the then former minister on the instruction of Attorney General?
No, I had nothing. I had absolutely nothing to do with it, because this is a murdering, this is an acid throwing incident. I had nothing to do with it, except that I received a complaint from the injured person saying that this investigation is being hushed up. So naturally, when I get a complaint like that, and I sent the DPP, Director of Public Prosecution, asked for a report.
That's a usual process.
Procedure. And then he wrote back to me and he said, yes, the OIC of the State Island Police has just put the file aside, he's not doing anything about it. And then I asked him, well, what do you intend to do? He said, no, I've already taken action. I've handed it over to the CID. Now this is CID with whom I had nothing to do. And the CID then thereafter investigated, and they made certain requests for arrest and so on, and Lalit was arrested on the instruction, on the AG's instructions. Then the investigation was over, and we had a situation where the DPP wanted to indict the person who threw the acid, the person who hired the person who threw the acid, the person who hired the man who hired the person who threw acid, and the person who took the first step of hiring these people, and that happened to be, according to the CID investigations, it happened to be Lalit. So that the DPP wanted to prosecute everybody and was prepared to go to court. The Attorney General had disapproved of it, had said, I can't authorize prosecution against Lalit. And they brought this to the ministry. So when they brought the ministry, the minister said, well, it is not matter that concerned us. But then they asked me to read the IB extracts and advise the minister what I thought about the Attorney General's complaint. So I read the IB extracts for about 3 or 4 days. And then came back and said, well, if I was prosecuting, I would present the case on a basis even different from what the DPP has said. And I mentioned that, and the minister said, okay, fine, the Attorney General. we have heard all this, you go back and you take a decision. And he took a decision not to indict. But the fact, what happened is at the first cabinet meeting after the change of government, the DPP was interdicted.
Right.
Based on compulsory leave. And he was, so now he has got to get back into service or at least get his pension restored. The Attorney General, it's a matter of record that he's the one who authorized the arrest. So they had to now find a scapegoat, and I was a useful scapegoat. And the judges also held against me. And why did I do all these vicious things of wanting all this done? Because they said there was a school day feud. The Attorney General gave evidence and said that they have heard that there was a school day feud between Lalit and me. Now, Lalit was my first friend when I came to Royal Primary School. We were in the same class throughout Royal Primary and Royal College, and he was a very close friend of mine. So, throughout, right along. But the Commission said that they accept evidence of the Attorney General that there was a school day feud and that I did this. So anyway, that was that. And of course there were other charges that I wanted to introduce barefoot lawyers into the legal profession. I made a statement to the press when the lawyers refused to participate in the legal aid scheme. I said, okay, fine, you don't come. We are setting up a brigade of barefoot lawyers who will join, who will provide legal. That was just we had no intention, but just a message to the legal profession. Then they found that another charge that I had convened judges' conferences, which we did. We convened a conference every year of all the judges, Supreme Court, High Courts, Magistrates, District Courts, everybody, to discuss matters. Which is good. Yeah, and it's open to the press. The press was there, and they covered all the proceedings, nothing in private. And they had complaints. They had complaints about staff not being made available, language problem. So we discussed those things. So I was found guilty. And the charge was that I did
like an annual review.
Yeah, the charge was that I convened these meetings and thereby sought to interfere with the administration of justice. So anyway, I was found guilty of out of the 40 of about 30 charges.
But you were ultimately pardoned in 1986.
No, we got a pardon. Yes, I was away in Hong Kong then, and
you was a professor for the.
Well, what happened is that when I found I couldn't go to the bar, then I went to London. Then I did my PhD. Now what do you do? Lawyer with a PhD.
And for the PhD you...
No, this is not my PhD. This is a book I produced when I was in Hong Kong. It's a judicial application of
So this is a book, The Judicial Application of Human Rights Law. Mr. Nihal Jayawickrama has produced in the year 2002, and there is a second edition as published in the year 2017, which I don't know how many lawyers have this book in Sri Lanka.
This is, I had to do that when I was teaching at the university. You're expected to write.
Right.
So I produced this book when I was in Hong Kong. So that when I found that with a PhD, what does one do? You had no option but to go into academic life. And I had applied to 2 or 3 universities because the notices were there at the London University notice boards. And the time came when they offered me an appointment. And I went there in 1984. 84 they offered me, I went in 85. And I was there till 1997.
As a
professor of law, I taught constitutional and administrative law, and I introduced a new course on human rights law. At first, there were no takers. There were 6 or 7 out of 150.
So
but
you
I managed to
initiated the human rights law.
At first, there was that little interest because Hong Kong people had no interest. They're interested in commercial law, but not in human rights law. So I had a small group of people, 6 or 7, which was enough to begin. Then the Tiananmen Square incident took place, where a whole lot of students were massacred, and that shocked and completely shook Hong Kong. And the next year, I had a class of over 100 out of 150 students, but 100 wanted to do it. So I had a big class. It became quite popular. So I taught that there, and I served there till the transfer of sovereignty, which also coincided with my retirement date.
I see.
They requested or they appealed to all expatriate professors to stay on for at least 5 years. And So I said, okay, I'm prepared to stay. But then they said, no, not you. I got a letter from the registrar say that no, you are not an extension. I think I've become rather inconvenient and embarrassment maybe to the university, because I was also the chairman. They elected me as the president of the International Commission of Jurists, Hong Kong section. So I became perhaps the most prominent spokesperson on the changes that were taking place in the constitutional arrangements for the future of Hong Kong for the next 50 years. And I was critical of some of those things. And this got a lot of publicity. Then the newspaper, Hong Kong English daily newspaper, asked me if I would write a column every week. So I had a Wednesday column in the middle page. Now that also is critical of the government,
and the human rights.
Hong Kong government as well as the Chinese government. And much of the Hong Kong government responded in a very gentlemanly way. If I criticized the governor, I would get a letter from him explaining why he did certain things which were
very good.
But it was different with the, so I think the Chinese government. So I had to, I left in 1997, and I was hoping to go to Perth in Australia, where I got an offer of appointment.
But just tell me, you were pardoning.
I was pardoned in
Sri Lanka.
Yeah, I received this document pardoning me
In 1986.
1980. Yeah, it was my civic rights was taken away in 81 for 7 years, I think.
Yeah.
But in 1980, after I went to Hong Kong, I saw it in the Hong Kong newspapers for the first time. All three of us, Mrs. Bandaranaike, Felix, who was dead by that time, passed away, and me, we were all given free pardons.
So, which you never asked?
No, I didn't ask for it.
Right.
It was okay. Free pardon means that it's different. I don't know whether you knew that free pardon meant. Free pardon is as if it never happened. Pardon is a different thing.
Yeah.
But anyway, in fact, it was such an impressive document with his red seal and Mr. Jayawickrama's signature that I had it framed and hung up in my office in Hong Kong along with my LLB certificate.
Free pardon.
Yeah.
Right. So you were appointed thereafter as the executive director of the Transparency International, the worldwide organization.
Yeah, I was hoping to continue my academic life, but a friend of mine who had been instrumental in setting up this organization called Transparency International, based in Berlin, had seen on TV at that time of the transfer of sovereignty about what was happening to me, and then he rang me up and said, why don't you come and join us? And I didn't know anything about transparency.
You were the first Sri Lankan, or the only Sri Lankan appointed as executive director in the international.
There was no one there. And I said, I'm on my way to Australia, and we have even given our permission for shipping. He said, no, but come and see. And just come and visit us. So I happened to be in London at the time, because my daughter was entering the university college there. And I went there. I was not impressed at all. Then I came back. And then I got a letter appointing me as the executive director on very attractive terms, same salary as what I would have received in Hong Kong, and said you can travel from London and come back for the weekends. That was not feasible. But then I finally made arrangements. We went and stayed in Germany. Transparency International was at the...
How many years, sorry, you worked?
Yeah, I went there in 97 December, 98 January, and I was there in 2001, because it was, in 2000 we moved to London, set up an office there, divided. It was, it's formative years. It was set up with the help of the World Bank to combat corruption, to formulate anti-corruption policies. So they did a lot of research about how corruption occurs and how do you deal with corruption of different kinds. There's grand corruption that presidents and ministers and permanent secretaries indulge in. And there's petty corruption, which is done at the lower level, where you got to give 10 rupees or 50 rupees to somebody to get some document through to the next level. There are different kinds of corruption. How do you deal with them? So we did a lot of research. And then while doing that, we also received a lot of survey results. Surveys of public perception surveys. What did people think of certain institutions? And also service delivery surveys, where people had actually come into contact with certain institutions and their experience. And we found that nearly all the reports from Latin America, from parts of Europe, Eastern Europe, from Asia, all in practically all found the police to be the most corrupt institution in many of those countries. And next to the police, the judiciary. They thought the judiciary was corrupt. And in fact, the survey done in Bangladesh, people reported that they had to pay, they were told they had to pay the judge, they had to pay the court clerk. They even had to pay the opposing counsel so that he will soft-pedal his client's case. So we decided that something should be done about this. How do you deal with judicial corruption? And judges are very sensitive people. And I found that in Hong Kong, because I was instrumental in drafting a Bill of Rights for Hong Kong. And we tried to organize a seminar and invited the judges. And the judges said, we don't need to be taught by anyone. We can learn it ourselves. They're very sensitive, so we didn't know how to deal with it. Finally, I wrote a letter from Transparency to a group of about 10, 12 Chief Justices from common law countries, because we speak the same language, from Nigeria, Tanzania, Uganda, South Africa, Australia, India, Karnataka, and we brought them together. UNODC agreed to fund it, brought them together and told them about what the public thinks about them. At first they didn't accept it, but then we said, this is what is shown and so on. He said, this is okay, fine. What is required is a statement of principles of conduct, because we don't have that principle of conduct, which is of universal application. So they asked me to prepare the draft code of judicial conduct by looking at codes of conduct wherever they existed, international instruments, all that. And I did that, and we had another meeting in Bangalore where my draft code of conduct was put to these Chief Justices. Chief Justice Sarath Silva attended that meeting. He made some very useful proposals. And then finally they agreed on a draft code which was called the Bangalore draft.
Yes.
Then there were certain shortcomings. This is the work of common law judges. So we have to now bring the civil law system in and ask, is this relevant to you? So we then had meetings with a body called the Consultative Council of European Judges, based in Strasbourg, with about 27 countries. They looked at it, they got a study prepared about it. The UN Special Rapporteur on the Judiciary was also on our team. Then it made certain changes. Then a number of organizations helped us to circulate this among Eastern European countries. Finally, we got a lot of responses, a lot of suggestions for improvements, changes, decisions. I prepared a final draft, and Judge Veeramantri, who was the chairman of this group, which called himself the Judicial Integrity Group, 12 Chief Justices with him as chairman. He was on the International Court of Justice at the time. He said, let's have this final meeting at The Hague at the International Court of Justice, and he said he'll invite the judges of the International Court of Justice as well. So we had this meeting in November of 2001. And the final draft of this code of conduct, called the Bangalore Code of Judicial Conduct, was adopted. It has gone through processes in the UN Human Rights Commission, UN Criminal Justice Commission, Economic, Social Rights Commission. Finally, it went to the General Assembly, and it was
UN General Assembly
approved. Then they said, we want a commentary on this, explain these things. So I had to prepare a commentary, which again went through the processes and was adopted by the UN. And they published it in all the UN languages. It's there now. And then some other implementation procedures. So we've been doing that work for several years, and unfortunately, no one here in Sri Lanka knows about the Bangalore principles. I've spoken to a successive Chief Justices, and they said, yes, please give us a copy, please do this. But nobody showed any interest. Sadly, at least 3 Chief Justices I spoke to about it, but they have done nothing about it. And we are one of the few countries, certainly in the Commonwealth, which have not drafted, has got a code of judicial conduct for judges. And because there are mechanisms for applying it and all that, but we have, even the United Kingdom used the Bangalore principles to revise their code of conduct.
So, one before the last, maybe the questions. Now, Sri Lanka is a bankrupted state, became a bankrupted state. Corruption is an issue in Sri Lanka. We had the Bribery Act, we have the Bribery Commission. Recently, we passed the Anti-Corruption Act. Do you see any lacuna in the law with regard to tackling corruption and bribery in Sri Lanka? Is there a change, a notable change has to be
No,
done?
I think our approach is completely wrong. Now, I haven't seen the final act, but I saw the draft, the first bill, and it's something like, I don't know, hundreds of pages, 160 sections or something like that. Hong Kong, which has perhaps the best record in combating corruption, the legislation runs into about 10 pages. I know I've been with the Hong Kong Independent Commission Against Corruption because I tried to get them to accept certain human rights principles and so on. I think the whole approach that we are adopting is not going to produce any results. We are, for example, we are banking on people submitting their asset declarations, not hundreds, not thousands. I think about 100,000 people according to the draft bill. Who declares stolen assets? Who declares? Who is the person who is going to declare if a person has assets which are hidden? He's not going to declare that. And you see what we found, or the research that we found in work that I did with Transparency International and also with the UN Office on Drugs and Crime, because I got involved in the drafting of the International Convention Against Corruption, and the approach we took there was based on work that we had done earlier. There are two forms of corruption. One is what they call grand corruption, which is what presidents, ministers, and the highest level people who have to decide on giving contracts, they indulge it. So it's a lot. Like at 1/3 the cost they give it to them. That's grand corruption. The other corruption is what we all experience in our daily life when you go to any government office. Because you got to, say you want to get a passport, you go to one person, then you got to go to another person, and third person, fourth person. So you need to give what they call petty corruption, or grease money they call it, because you've got to grease their hands to get this thing through. Now you deal with them in different ways. That kind of petty corruption, which is prevalent practically in every government department, has to be dealt with by reform, administrative reform. The more gatekeepers there are, the more money you have to pay. Remove the gatekeeper. Simplify the procedures. Do you need to give all this information? Is it all that necessary? Is that available in some records? So you simplify the procedure. It's all administrative reform. That's what you do, and you help people's lives by doing that, because they don't have to go through this complicated procedure. The other one, they are not going to, minister is not going to declare and say, I have got this money by the commission, that money. No. You have to observe their lifestyles. And there's an offense called illicit enrichment, which is there in Hong Kong, which they have been introduced into our bill, but in a very small way. Where if the Bribery Commission observes the lifestyle of a targeted individual and finds that, for example, his sons have got Alfa Romeos and a huge house somewhere in Cinnamon Gardens, then you ask that person, call upon him to declare how his family acquired that wealth. And he is presumed to be guilty of bribery until he can clear himself. So that is how you do it, and that is how it has been done in Singapore and in Hong Kong. That's how you deal with it, not by asking 100,000 people to submit asset declarations. So that's why I think we are doing it the wrong way with the elaborate machinery and so on. So I'm not hopeful that we can deal with and of course there is also a unit set up in the World Bank called the Stolen Assets Recovery Unit, which is a World Bank and the UN office in Vienna, which I've been dealing for the last 10, 20 years almost. They are able to access bank accounts in any bank, anywhere in the world. Even if it's numbered, they can find the names. They can also get the help of the FBI or various other investigating agencies. But the government has to request them for assistance in regard to specific individuals. If the government requests them, they will be able to provide that service. I have worked with
as long as government is not asking assistance.
In Egypt, when the President Mubarak was overthrown, they had that Arab Spring. Then the government that came into power, they asked for search the assets, recover the assets of the Mubarak family. And I was on that team that went there from Vienna. And we were able to find a lot of property belonging to the family and so on. That is a stolen assets recovery unit in Washington. But the government has to make requests, otherwise.
So with all your experience, no doubt that you brought goodwill to the Sri Lanka as a proud Sri Lankan working for different international levels. What would be your advice for the young lawyers who are entering the profession, who may think practicing law in the court of law is the only option they have?
I don't think that is the only option. That's the only thing that I wanted to do, but then I found that there are so many fields that are open. So my life story is really one of like que sera, whatever will be, will be. I only wanted to practice and nothing else. So a young lawyer who has that same ambition will find that if something difficult is crossed their way, there are so many other options that are open to a lawyer. And I think they should take them. When the opportunity comes, they should take them. The bar is not the only place. I've been, the last 20 years, I've been working with the UNDP and UNODC in Vienna on a number of reform programs. For 10 years, worked with the Court of Cassation, that's the Supreme Court of Turkey. And their situation was much worse than ours, where tremendous backlog of cases, but their whole appellate structure had to be restructured. And they were very keen to introduce codes of conduct for their staff as well, which our group had done. So that reforms have taken place in so many countries, but unfortunately not here.
So thank you very much, sir, for sharing your experience with this interview. And I wish you all the best for your future years. Thank you.
Thank you.